Law must change with the society to remain relevant with it. India is rethinking to abolish 152-year-old law for protecting human rights and freedom of speech of nearly 1.4 billion population. The re-examination of sedition law will only uphold the democracy of India. Hello and welcome to Juriset channel. In this video, I will be discussing some relevant points with respect to the sedition law given under section 124A of IPC. I request you to watch this video until the end because the points which I will be discussing will be relevant for every type of competitive exams. First thing first, let's see the background of this law. So originally, section 124A, it wasn't a part of IPC in 1860. Later, it was added to the Act in year 1870. Why? Just to counter the surging Wahhabi activities in the subcontinent. The first case that was registered under the sedition was in year 1891, and the case name was Queen Empress versus Jokendra Chandra Bose, where the editor of a newspaper was booked for publishing an article, but the jury couldn't reach a unanimous verdict. And then the editor was released on bail, and after he issued an apology, and the charges against him were dropped. Now, the trial that changed the effect of Section 124A was that of Bal Gangadhar Tilak in 1897. The British government claimed that the Tilak speech on the killing of Afzal Khan by Shivaji had prompted the murder of two British officers in Pune. And there, at that time, there was a newly promoted justice named as James Strachey. He presided over this trial, and he broadened the scope of Section 124A in the proceedings by equating disaffection to disloyalty. Moreover, Mahatma Gandhi in year 1922 was charged under this section, and he famously denounced the law against sedition in the court by stating that Section 124A, under which I am happily charged, is perhaps the prince among the political sections of the IPC designed to suppress the liberty of the citizen. Hence, all these were major events that occurred during pre-independence. Now let's see the case that has defined the scope of sedition for the first time. The name of case is Kedarnath versus State of Bihar, decided in year 1962, where the Constitutional Bench of the Supreme Court has tried to restrict the scope of sedition for the first time. And this definition has been taken as precedent for all matters pertaining to Section 124A ever since. I have mentioned the Supreme Court observations before you. And let me simplify the whole understanding that strong criticism of any policies of the government cannot and wouldn't be considered to have penal consequences, but disloyalty to the government would be punished. Therefore, a speech that suggests the government established by law was dishonest and unlawful, and so steps should be taken to abolish it through force or the threat to force, that would come under the purview of Section 124E. So this is the whole gist of the Supreme Court made under the Kedarnath case. Let's see the judicial trends in relation to crime of sedition. There are numerous cases which has been filed under Section 124A of IPC, but I have chosen the vital ones. In Tara Singh Gopi Chand versus State of Bihar and Ram Nandan versus State of UP, so these both cases are decided in different years, but the same thing was held, which was that Section 124A was held to be ultra-vires as it imposed restrictions on liberty of speech and expression, which was contrary to the interest of general public. But if we refer the case of Kedarnath Das, this landmark judgment has become the ruling precedent on sedition and remains the basic till date. Why? In this case, the Supreme Court upheld the constitutionality of Section 124A of IPC as against Article 19 of the Constitution, but with the necessary caveats. Next significant case is the case of Balwant Singh versus State of Punjab. In this case, the Supreme Court held that raising casual slogans by two individuals a couple of times without intention to create disorder or to incite people to violence doesn't attract Section 124A. However, if public disorder with an intent to incite violence is given way, then such slogans are unconstitutional. Therefore, Balwant Singh case doesn't legitimize all types of slogans against the country. In 2012, Indian politician cartoonist Asim Trivedi created and published several cartoons online that allegedly defamed India's parliament and the constitution, and that has spread hatred towards the government. He was charged with the offence of sedition under Section 124A of IPC. Next case is PJ Manual versus State of Kerala. This case involved a poster that exhorted people to boycott legislative assembly elections. This poster and its circulation charged the accused under Section 124A, to which the Kerala High Court observed that even Section 124A must be read with the intent and spirit of the Constitution. It further appreciated the essential ingredient of incitement to violence and the true meaning of disaffection against the government in modern times. And with all these interpretations, it has led to the acquittal of the accused. In the case of Sanskar Marte, a similar view as we have discussed in the Asim Trivedi case, the court has also come out with a series of guidelines to be followed by the Maharashtra police before booking someone for the offence of sedition. Similarly, Section 124A was imposed on Arun Jaitley in 2016 when he was a union minister in the central government. He wrote a very strong criticism of the Supreme Court pronouncement on NJAC, where the Arun Jaitley referred to the judgment as tyranny of the unelected. However, it was quashed by the High Court of Allahabad. Further, in the case of Common Cause versus Union of India, it was held that the authorities, while dealing with the offences under Section 124A of IPC, will be bound by the principles laid down under the Kedarnath Singh versus State of Bihar, and the sedition charges cannot be invoked merely for criticizing the government. Hence, apart from all these case laws, there are numerous cases where the students and the activists have been slapped with Section 124A, whether appropriately or not so appropriately. In 2021 as well, we have witnessed several cases under sedition law, and the case names which I have mentioned before you is just an illustrative list. And out of these cases, some of the cases are still pending before the court. If I talk about Vinod Dua versus Union of India, the FIR was lodged against journalist Vinod Dua over his YouTube show on communal rights in Delhi in 2021. But the court has quashed the FIR on the ground that only such activities would be penalized which would be intended or have a tendency to create a disorder or disturbance of public peace by resorting to violence. Whereas, if I talk about Rajat Sharma case, where the PIL was filed against the ex-GM of JNK, Farooq Abdullah, for his pro-China comments over the abrogation of Article 370, the court dismissed the PIL and held that expression of views which is dissent or different from the opinion of government cannot be termed seditious. Now let us also once consider the language of Section 124A, according to which the Act will be penalized if anyone by using words, signs, or by visible representation trying to bring hatred against the government or excite or attempts thereof the disaffection against the government of India will be punished for 3 years of imprisonment. If you refer explanation 1, the term disaffection has not been defined. It just merely states that it includes the disloyalty and all feelings of enmity. Whereas explanation 2 and 3 provide the exemptions. Also to note that the term sedition has not been used throughout the section. The nature of this offence is quite serious since it's cognizable, non-bailable and non-compoundable. Now let's see the major problems associated with this law. So first, the main problem with this law is that it has been poorly defined. The terms like bring into hatred or contempt or attempt to excite disaffection, they can be interpreted in multiple ways. A democracy requires citizens to actively participate in debates and express their constructive criticism of government policies. However, the sedition laws have empowered the executive branch of the government to use the ambiguously defined provision as an instrument to regulate public opinion. If we see the instances before us, it can be said that the sedition law has become a tool to instill a sense of compliance towards government policies in the citizens. Yet, what is more concerning is that once a person is arrested under the sedition law, it is extremely difficult to get bail as the trial processes can be stretched for long. This leads to the harassment of innocent people and induces a fear in others to speak against the government. Let us also see to the viewpoint of Law Commission of India. In August 2018, the Law Commission of India published a consultation paper recommending that it is time to rethink or repeal the Section 124A of IPC that deals with sedition. And it has rightly quoted that expression of frustration over the state of affairs cannot be treated as sedition. If a country is not open to positive criticism, then there would be no difference between pre and post independence era. Now let's see to the case which is hitting the headlines. It is SG Bombat Khere versus Union of India. The court took cognizance of the case that Section 124A dates back to 1898 and predates the Constitution itself and is being misused. The court also took cognizance of the Attorney General representing Union of India, who on earlier date of hearing had cited instances of misuse of this very provision. Therefore, the Supreme Court on 11th of May 2022 directed the centre and the states to keep in abeyance all pending trials, appeals and proceedings with respect to the charge framed under Section 124A of IPC. So by now you must be thinking that what will happen if Section 124A gets repealed? What will happen if a person conspires against the state? How he can be penalized? So yes, if a person conspires against the state or if he attempts or if he abates against the government of India, then he can be penalized under Chapter 6 and Chapter 7 of IPC. And with that respect, with that particular case, other special laws can also be attracted. Thank you for watching this video. Do let us know that what is your opinion regarding the sedition law, and do subscribe Juris Academy to get the further updates.